This episode of Crime Time is brought to you by Scared Away. When your prosecutor looks like she might put you in a cell all by herself, drink Scared Away. It's like being square and okay, but for criminals.
All persons are innocent and unafraid until proven otherwise. Thanks, and have an okay day. And choose Scared Away. And now on with the show.
Mr. Boyin,
Yes, ma'am.
raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. You're before the court on 2022 CR 07029 for Judgey Benjamin Boyin for simple assault count 1, firearms discharge count 2, and reckless conduct count 3. You're represented by the law firm of Lister, Holt, and Dennis. Mr. Taz Taylor is with you. You were before the court pending a motion to revoke bond. However, you're taking a plea and going forward with a plea. By entering a plea, what is your client plea to the offenses before the court, Mr. Taylor?
Your Honor, my client pleads guilty to the 3 charges before the court.
All right. By entering a plea of guilty to counts 1, 2, and 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf. Do you understand all of these things, sir?
Yes, ma'am.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On or about June 15th of 2021, based on the warrants in the packet, the defendant got into a verbal altercation with his live-in girlfriend at that time, Alexis, Alexis. The victim's sister, Kanisha, Kaneis, as in Sam, HA, traveled over to the defendant's home to remove her from the location to avoid the defendant. Ms. Kanisha advised that while she and her sister, Alexis, were walking to the incident location, the defendant followed them and discharged a 9mm firearm in the air numerous times. Ms. Kanisha stated that she reacted by discharging her pistol back in the, her pistol back in the area of the offender to protect herself and her sister, Alexis. During Officer L. Covington's investigation, he did collect 12 9mm shell casings from the roadway of the incident location. Also 9mm bullets were recovered from the incident location as well. Your Honor, at this time, the state's recommendation is going to be 12 months to serve 90 days. Balance probated. The defendant is to go to a gun safety course and to forfeit his weapon.
Okay. And this is concurrent to all 3?
Yes, Your Honor. The defendant can receive credit for time served if he served 59 or 60, but the state is requesting 90 days.
Okay. All right, Mr. Taylor.
Your Honor, after speaking with my client, we decline that offer. We'll stand by our not guilty.
You all can go non-negotiated.
Yes, we are, and we're standing on our not guilty.
Okay.
All right. So, Mr. Boyin, not guilty. We'll see you on your trial date. And also, my understanding is there's another case pending. If you're going to go not guilty on both of those, we'll do our best to try them as close in time as possible, if not on the, during the same trial week. All right. You can go back with the sheriff's office.
And Your Honor, since the state, I guess our position would be, since the defense is not moving forward with the plea, again, Officer Moore is on. The main purpose of today's calendar was to revoke the defendant's bond. And so we're ready to proceed forward on the motion to revoke bond.
All right, Mr. Boyin, come on back.
Your Honor, we've changed our position in the matter. We will accept the state's recommended sentence of 90 days rather than the 60 that we thought we were receiving. We'd like to go forward with the plea.
All right. So the court is going to impose on counts 1, 2, and 3, 12 months to serve 90 days to run concurrent for each of the counts. Balance will be probated for Mr. Boykin to take a gun safety course, and he's to forfeit the weapon and not have any other firearms in his possession until he has been certified as having taken the gun safety course.
Understand? No firearms until you take them.
All right, Mr. Boykin, my concern with this case is, sir, y'all were in the middle of the street having an OK Corral shootout when you don't understand that bullets have to go somewhere. When you shoot a bullet up in the air, do you understand that it's coming down somewhere? And it may not come down where you intended in the ground. It may come down on the top of someone's head. Had a case about 4 years ago where a woman shot into the air trying to break up a fight in her front yard, and she ended up killing her own son because the bullet came down on his head. So, sir, when you out there just throwing bullets at each other like y'all don't have no good common sense, y'all are liable to kill somebody and not the person you intended to aim at. You shooting in the air, she shooting at you. Y'all acting like y'all don't have like y'all don't. Crazy. It's just crazy. It's just crazy. First of all, people act like they don't understand that guns can kill folk, and I am a major proponent of gun safety. If you're gonna have a gun, have it secured safety, operated safety, know what it can do, and know what it's not supposed to do. Y'all picking up guns like it's the OK Corral out here, just shooting at each other, just crazy. What about contact provisions?
Yes, Your Honor. I know that on the previous bond order, the defendant was told to stay away, which is how I ended up picking up that new case.
Then you'll stay. Then the court will renew its renew its order that you stay away from Ms. Kanisha. Because as one of my friends says, y'all don't have good common sense. All right, you can go back with the sheriff's officer.
Thank you, Judge.
Calling 2015 CR 9437, State of Texas versus Alfonso Sosa. Can I have parties announced for the record for the state?
Zach Dunn for the state.
Defense?
Nathaniel Navy for Mr. Sosa.
And are you Mr. Sosa?
Yes.
All right, did you review the motion to revoke with your attorney? Did you understand it?
Yes.
Are you the same Alfonso Sosa who was placed on community supervision in 2015 CR 9437 for the offense of assault, family second offense on May 21st, 2019 for a term of 6 years? Is that you?
That's me.
All right, state.
Violation of condition number 5. In Bexar County, Texas, the defendant, Alfonso Sosa, did then and there fail to report to the supervision officer in person or through virtual means for the months of August 2020 in violation of condition number 5.
How do you plead to that? True or not true?
Sure. Your Honor, the state will waive and abandon the others.
Any objections?
No, Your Honor.
Did you understand by pleading to violation of condition number 5, the court could find it true, grant the motion, all right, we need to go back on the record. I'm sorry, we're still on the record, but we need to go over this again. Because this says motion to revoke, but I'm looking at the judgment and it shows that you're on deferred adjudication. So, yes.
And I just have something to add to that, Judge. He had a motion to enter an adjudication of guilt in 2019. The state and I were a little bit confused on that as well, because then the judgment said that he was sentenced to 6 years. There's a little tiny box on there that said sentence suspended and probated for 6 years. So I thought it was incorrect as well at first, but then I went through the court's file and I saw that. So I think it is correct. He was just, he was found guilty in 2019, and now he's back on a motion to revoke the probation.
All right, thank you. So did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, and sentence you up to 6 years in prison? Did you understand?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor,
Yes.
for 2 years TDC.
All right. So what has he done on probation? Has he done anything?
So
He
there
com-
was, in the beginning, hold on, I'm flipping back, Judge. I think there was a completion of safety. And that was back in 2020. And then there was a CAP completed back in 19. And then, as of course, the court knows, this MTR actually originates, even though the state waived and abandoned the other conditions, all three of them are over 4 years old, those violations, the August 2020. So that is the knowledge that the state has with respect to a court summary of what this individual has done.
Defense?
Yes, Judge, I'd like to provide a little bit of context and hopefully some mitigating circumstances for the court to consider. Mr. Sosa is homeless. He was ordered to complete the SafeP program. From my understanding, he was transferred to Austin, and that's where he completed it. He did the aftercare program there. He was released, and he asked, I don't know who he asked, if it was somebody with the program or somebody with probation about getting back to San Antonio. He was told that, everybody has to organize that on their own. And so, because he was wondering about a bus ticket or something like that, he's homeless, completely indigent. And he actually, I believe, remained in Austin from when he was released all the way until when he was picked up, because I think he was arrested there and actually extradited here from Austin. So when he was released, he just remained in Austin. So due to those hardships, he kind of remained there, Judge. It wasn't a situation where all he had to do was, go somewhere and he had access to it.
All right, because this is Judge Charles writing probation.
Yes, Judge.
So is this true that if you're transferred to SafeP in Austin, they do not provide transportation back once you've completed it?
Judge, that's something I'd have to look into. If you give me just like 2 minutes, I can find out.
Sure. All right, so if you all will step back.
Okay, Judge.
So we were here, I think, on Monday or Tuesday. We got recalled to today because the state was trying to reach their witness. I believe they did, well, I don't want to speak for them, but they reached the witness. I know she's opposed to it, but I'll let them speak to that.
All right. All right, we're going to go on the record in 2023 CR 10223, State of Texas versus Carly Green. Can I have parties announced for the record, for the state, for the defense?
Adam LaHood for the defendant.
And are you Miss Green?
Yes, ma'am.
All right, this is a continuation of a previous hearing, and it's in regards to the motion to modify bond conditions. Defense is asking for GPS to be removed.
That's correct, Your Honor.
All right, state, you're going to speak to the complainant.
Yes, Your Honor, and we did. The complainant indicated to us that she opposes removal of GPS, that she still fears the complainant. Additionally, our complainant is available to testify as soon as the court wants.
All right. So here's the issue. The issue is, I don't know anything about this case other than she's charged with aggravated kidnapping. So I'm assuming the aggravated kidnapping is the complainant that you've spoken to? All right. So does anyone want to give me what they think? Well, let me strike that. So it's aggravated. There are different ways that it can be aggravated. So what's alleged to have made this aggravated?
They're alleging the presence of a firearm in the indictment.
All right. And allegedly, what is her relationship to the complainant, if there is one?
Acquaintance at best, friend, kind of at a mutual get together.
Okay, so here,
Best phrase, Your Honor, is social acquaintance.
There you go.
so here's the court's other question. She's on tracking, correct?
Yes, Judge. She's allowed to go to the grocery store, but otherwise she's, are you working? Yeah.
So here's the question then. Would there be an issue if she's just on tracking, period?
No.
No, not from you.
Sorry.
I know
You're
you,
okay.
you don't. State, do you have any issue with her just being on tracking? Because then the complainant will know where she is. At least the state will know where she is.
I have not asked the complainant question, Your Honor. I don't know if anyone on staff can answer, so I don't know the answer to that question.
But would parties agree, doesn't tracking take care of whether or not she's had contact with the complainant? If you all want to put in the court's order, I'm going to do tracking only. The last hearing we had, she's been on GPS for a long time now. I will do tracking only. State if you have a location area that you do not want her to be in. If you all can agree on what that location is, then I can include that as an exclusion zone.
Perfect.
Understood.
All right, so I am going to deny removal.
Okay.
It will be tracking only with an exclusion zone. So if you all will write in here, the exclusion zone for the court,
Yes, ma'am.
is there anything else?
Nothing from the defense.
Okay.
Thank you.
So if you'll write that in here,
Thanks.
thank you.
Thank you very much.
But Sean, are you ready on Sosa?
Yes, Judge.
All right, we're back on the record in 2015 CR 9437, Alfonso Sosa. Ms. Abrams, what did you discover?
So Judge, typically it would be the responsibility for the defendant to find his way home after the Austin Transitional Center releases them. However, we try to work, they have the ability to work to get the funds. They work closely with them to get the funds to be transferred back. Back in 2020, the staff that we have currently was not managing that unit. So things have changed. Just so that we're fully aware, what happens now is they work hand in hand with nonprofit organizations to get the funds to get the defendants back to where they came from.
Okay.
So at that time, that may or may not have happened. We don't have record of that. But to answer the court's question, it is the responsibility of the defendant once they are released from the transitional center to go back to where they reside.
Okay. All right, thank you. Mr. Sosa, are you asking the court to follow this agreement that's been reached?
Yes,
Are you waiving your right to appeal?
yes,
All right, the court will follow your agreement. The court is finding violation of condition number 5 true. There's an affirmative finding of family violence, 2 years in the prison. Give you credit for any time served, and I'll give you credit for time in inpatient treatment that was successfully completed.
Thank you, Judge.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
yes,
Did you understand it?
yes,
And did you sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
yes.
All right, do you have any questions about anything? All right, we can go off the record. I'm sorry that at that time they were doing things where they place you in a completely different location and expect someone who's homeless or who's recently released from inpatient treatment, which you have no money because you're in inpatient treatment, for them to expect you to make it back here on your own. All right, good luck to you.
Thank you. Good luck.
All right.
And